This is a legal topic and it is one of the most fundamental topics in evidence appreciation, particularly those who are into trial advocacy. For them, this is extremely important. For the persons who want to understand how evidence appreciation is done, this topic is extremely important. Without this topic, it is impossible to know and understand documentary evidence. It is not as easy as it looks. Just producing this is not enough to prove this. What is the complete proof of a document? I will read whatever is written here. You can see the screen and see, read it. What is written there? I'll give you half a minute. Now, I'll read it. What is written here is this. Madgaon, Goa, 14th of June 2023. Bhau, which means brother. Bhau, I was hit very hard 15 times by Mr. Edgar. I tried to avoid his hitting, but he continued. He wanted me to give him 15 lakh rupees 15 lakhs, but I refused. I had refused to give him the amount, because of which he hit me. And then there is signature, and below the signature is written Pandit Desai. Now, in a case filed at the instance of Pandit Desai, which means either a complaint case or an FIR. This is obviously for the lawyers, persons who supposedly know law. This is not for normal persons. This will be bouncers of knowledge for normal persons. This is only for the lawyers who want to know accurately as to how to evaluate documentary evidence. Evaluating documentary evidence is extremely necessary for proper judgment, and unless evidence appreciation is known at its very best, it is impossible to cross-examine properly, because it is by keeping the final arguments in mind that a cross-examiner should cross-examine. Now, coming to this point, let us say that Pandit Desai has either filed a complaint case or has filed an information which is registered as First Information Report (FIR) by the police, and thereafter a charge sheet is filed in the court. In either case, the matter, let us say, is pending for trial. Now, in the trial, how to know what worth it has and how to evaluate the worth. Now, the case is against Mr. Edgar D'Souza, let us say, or Mr. Edgar, whatever surname. The surname is there in the charge sheet or in the complaint. In this, it is not there, no problem, because it says that Mr. Edgar. Let us say, to complete it, I can even write the surname here. Let us say this surname is written here. The case is filed at the instance of Pandit Desai against Edgar. Pandit Desai might have filed a complaint case depending on the section, whether it's a private complaint or not, or it might be a charge sheet filed by the police at the instance of Pandit Desai. FIR registered on a complaint, which is generally called complaint by laymen. Actually, in legal terminology, it is called information, first information. So, either first information is given to the police, subsequent to which FIR is registered and a charge sheet is filed, or it's a complaint case. In either case, now the topic is how to understand the worth of this. The topic is how to know whether a document is completely proved. How to know whether a document is completely proved. The first step. Is it enough just to give this paper? Is it enough just to give this paper to the court? This paper is given to the court. Will it be enough? Let us say it was alleged that this was posted. This was posted. It is alleged that this was posted by post, ordinary post. If it is registered post, then the registry also will have to be proved. If it is ordinary post, is the envelope supposed to be proved or not? Or is it possible that this is a note written somewhere else just by writing that this is Madgaon, written at Madgaon? Is it possible that this is written in Karwar, yet it is stated here that it is written in Madgaon? Nobody proves that this was definitely contained in any envelope, postal envelope. Nobody proves it. Will that be enough? If there is objection, will that be enough to prove that this is written at Madgaon in Goa? Or is it necessary to prove that this was definitely written in Madgaon and not in Karwar? How do you know? And how does anyone know whether this is a note written in Karwar by writing falsely that it is written in Madgaon, or whether it is a note actually written in Madgaon and posted and subsequently obtained in Karwar? How does one know it? Is the envelope necessary? And is it necessary that the witness tells that the same envelope which is produced in the court contained this note only? Is registry necessary if it is contended that it was posted? Or is plain envelope necessary or enough? How much is enough? And who should prove it? Evidence is not as easy as it is thought to be. Law of evidence is not a game of peanuts. So how does one know whether this is truth? How does one know whether this is accurate? How can one say that this is completely proved? Can you write it down before listening to the video further on a piece of paper? What is necessary to prove a document? What are the essential steps which are necessary to be completed to say that the document is completely proved? Whoever is listening, please pause the video and write on a paper with a pen or on your computer, laptop, whatever, mobile phone, Samsung Notes or whatever. You write as to how documents are completely proved. What is the difference between taking on record and marking in evidence and complete proof of documents? What is the difference? If I give this in my deposition to the judge and he takes it on record, is that proof? Will that be enough? Let us make it a little more complex. If there is no cross-examination about this, and taken on record in the chief, examination in chief. Is that complete proof? Again, I am pointing out, evidence is not peanuts. The law of evidence is not a game of peanuts. It needs high level of intelligence to understand these concepts. It needs very high level of knowledge and the application of that knowledge. Now, I'll start how it is done. Now, if the contention is that this was just a note, then it is not necessary to prove through any witness that this was posted. But if it is contended and alleged that this was posted, then there has to be some witness who proves that this was received in some envelope and that he has the envelope, because that also forms part of the document. If he claims that it was received by ordinary post, he should deposit, he should stand the test of cross-examination that it was received in a particular envelope. If it is registered post, then he has to prove it even further. It's easier though, if it is registered. Now, what if nobody proves that this was received in an envelope through the post? Can it be said to be a letter? Or is it a note written maybe somewhere else and simply written as Madgaon? How does one know this? Evidence law is not peanuts. It is the toughest law in the entire legal sphere. It needs the maximum level of brains. And not just that, it needs lot of application of complete knowledge. But I have gone through so many instances where many lawyers who claim that they know this actually don't know this. Most better lawyers know it. Not all know it. Okay, now the point is, the first step in proving any document is produce this document. That will be primary evidence. If the document is original, anything written here on paper is a document, right? Now, this, if it is original, it becomes primary evidence. If, let us say, somebody possesses a copy of this, and whether it is to be taken on record or not will depend on section 65 of the Evidence Act. Go through section 65 of Indian Evidence Act. Section 65 of Indian Evidence Act. Cases in which secondary evidence relating to documents may be given. Okay? When the original is in the possession of some other person, then that some other person has to produce the original. And you have a copy, you can produce copy. And you can say that this is secondary evidence. If the original is admitted, meaning the other party says, yes, I admit that the original is a copy, is the original copy of this, and this is an authentic copy, Xerox. A Xerox is called copy in law. Okay, so the original is admitted and you offer a copy. Third, original has been destroyed or lost. How can you produce something that is destroyed or something that is lost or has become extremely wet in the rain and has got mutilated? So you have a copy of it, you give it, but you have to prove that you have lost it or it has been destroyed. When the original is not easily movable, these are rare situations, yet they can be there. No, everything is not in the form of a paper. Sometimes it is something else other than the paper, and it cannot be brought to the court. Then you can bring a photo of it. That becomes secondary evidence. Because the original is not movable easily. When the original is a public document, some official document, they will not give you the file, official file. They will give you a certified copy if you ask for it. as per the procedure. When the original is a document of which certified copy is permitted by this act, by the law. When the original consists of numerous accounts of or other documents, and the fact to be proved is just a general result of the whole collection. So these are the situations in which secondary evidence is admissible, meaning copies or photos or whatever. And in which case, what can be admitted as secondary evidence is written here. In cases A, C and D, any secondary evidence. In case B, written admission is admissible. In case E or F, a certified copy of the document and no other secondary evidence is admissible. Now, this is the first step. That means you either give this original if you have it, that is primary evidence, and if you don't have this, you can give a copy of this, xerox of this, right? But will that be enough? The court takes it on record, let us say, and marks it as exhibit. Any document, when it is given now, to refer to it again, it is given a number. The way there are roll numbers in the schools and colleges, there are exhibit numbers given to documents, so that each document can be easily identified by its number. It is called exhibit number. But suppose if you have a roll number, let us say roll number 15, does it mean that the boy is authentic? That he always speaks the truth? Is it that just because this is given a number, does it mean that everything written here is truthful? Just because it is given a number? Just because somebody has a roll number, does it mean that he is a topper? Does it mean that he knows everything? Does it mean that he always speaks the truth? Nothing further. It is just an identity. It is just given an identity number. That is the worth of marking it as an exhibit. So which means that just by giving it a number, marking it an exhibit, does not mean that it is proved. It is just given an identity. The way roll numbers are assigned to students, it doesn't mean that it is proved. Okay, now this is the first point. You have given either a primary or a secondary copy if admissible under the situations. Under the situations, because there should be a situation which you must prove to give a secondary evidence, to give a copy or a photo or whatever. If those situations exist, you can give secondary evidence, right? Now, this is given, this is taken by the court, but it does not mean that this is truthful. A roll number does not mean that the student is a topper, or that he is always truthful, or that he is always complete. Exhibit number is like a roll number, that is all. It is for identification. It does not mean that it is proved. It is just taken on record. It is given a roll number, that is all. What is the next? See what is written there. Bhau, I was hit very hard 15 times by Mr. Edgar. I tried to avoid his hitting, but he continued. There is an allegation of hitting, and there is a reason written there. Now, if I write that I own half of Goa or half of India, does it mean it is truth? If I own, let us say, one house, and I write that I own half of Goa, is it truth? So what is the next step? What is the next step? The next step is, if I have written this, I have to give these through the witness box while deposing to the court. Because I have written it. I am the author. I am the writer. Okay? Now, if somebody else says, somebody else has written, if I say that I am not Pandit Desai, but my relative is Pandit Desai, and he has written this, who can say that it is truthful? I don't know whether Pandit Desai is accurately truthful or not. Court doesn't know it. Who knows it? How does one know whether this is truthful or not? And how do I know whether it is actually written by Pandit Desai? So, I should have either seen this being written by Pandit Desai, or I should be knowing his handwriting, or there may be a handwriting expert called to prove that Pandit Desai actually wrote it. Which means I must have either seen Pandit Desai writing this, or I should be knowing Pandit Desai's handwriting, or there should be a handwriting expert to prove that a sample writing of Pandit Desai, which is known as Pandit Desai's writing, is the same as this writing. In either of these ways, the second step is completed, which means it will be proved that this is written by Pandit Desai. But after this second step is completed, is it proved that this is truthful? It is written that somebody has hit. Is it enough? Now the original is produced, and what is written is proved to be written by the person who supposedly has written this. Is that enough? Is it truthful? Is it truthful? How do you know whether this is written under compulsion, under pressure, or how do you know whether the person is a liar? So there are further things to be proved. What are those further things? It must be proved that this person wrote this under no compulsion. He wrote this in a fit state of mind. He wrote this when he was not under a state of being drunk, alcohol, that he was in a fit state of mind, and that he wrote it voluntarily and truthfully. Who will prove it? We are coming to the third step now, that it is authentically written, truthfully written. How does one know it? See, if I have seen Pandit Desai being beaten by Mr. Edgar, I can say I am an eyewitness. But if I am not an eyewitness, I am no one to prove whether this is truthful or not. I only know the handwriting. This is written by Pandit Desai. This is what he wrote. But whether he wrote it truthfully and voluntarily is the third question and most important question. Who will prove it? Only if somebody has seen this happening, the hitting, he can say that he knows that this is truthfully written. Secondly, if Pandit Desai actually comes and deposes through the witness box, that is the second thing. Some eyewitness, either the victim himself or somebody who has seen this incident, is eligible to say that it is truthfully written. Which means these are the three steps in the examination in chief. One, the primary or secondary evidence of it, the document itself or the copy or photo of it. Second, that it is written by the person who says that he has written it, or who it is claimed that he has written, which means the proof of handwriting, that some person has executed it. Any person who has written is said to have executed that document. Somebody who writes for somebody else is called the scribe, writer. Suppose if I am talking and somebody else is writing my words, he is the scribe. S-C-R-I-B is the writer. So, the scribe can prove that it was written by him based on what somebody else said, or the person who has written it as his own version can come, or somebody who has known the handwriting, somebody who has seen the writing while it was being written. That is the second step. And the third step is to prove that it actually happened and that the person either saw it or was the one who was the victim. And that is why he has written this. But this will be only the examination in chief. So these are the three things which are essential in the examination in chief, then the verification remains. Cross examination is for verification. Otherwise, somebody may talk lies by preparing well. He may fulfill all these three requirements. I have proved the primary document also, I have proved the handwriting also, and I am standing in the witness box and I am saying that this is what has happened. Somebody who says this may say it because he is a liar also. So he has to face the test of verification, which is the cross examination. Which means whoever says that he has seen this happening should stand the test of cross examination. And if nobody stands the test of cross examination in relation to actually seeing this, the document is still not proved in spite of fulfilling other requirements. Get it? The point is, the person should stand the test of cross examination, because in spite of fulfilling the three steps, it may still be lies. And that lies, if it is, it can be caught in the cross examination. And cross examination itself is an art and a method. It is both a science and an art. It needs many skills of mind management, of knowledge, of method, and of the art of handling minds, which minds may be revealing part truth or maybe lies, maybe truth also. So, which means unless anything is cross-examined, it is not evidence completely. Which means if somebody says this has happened, he should stand the test of cross-examination. How to do cross-examination is not the topic here. It's an elaborate topic. But these are the steps to prove a document completely. If either the primary evidence or secondary evidence is not given, the document is not proved. If the handwriting or the execution or the writing itself is not proved to be by the person who claims to have written this, the execution is not proved, and the contents, if they are not proved to be truthfully written, and if they are involuntarily written, or if they are written under pressure or because of lies, the document is a facade. May God bless you.